Hello, my name is Austin Gilley, and my fatherhood is on trial with AI. This is step 12. In step 11, Claude rendered its verdict. 7 questions answered live in one sitting with no second takes. This step is the reasoning behind that verdict. Step 10 laid out the law this case would be measured against. Step 11 gave the judgment, and now step 12 is the written record of how Claude reached it, the findings of fact and the conclusions of law. A court would call this its findings and conclusions. Here it is Claude showing its work, and it will be followed by Claude's discussing some of the implications going forward. The slides that follow are entirely Claude's words. At the end, I will make a few personal comments. Before the findings themselves, a word on what this is. In step 11, Claude answered 7 questions and rendered a verdict live in one sitting, stating its conclusions without stopping to lay out every reason behind them. This document is where those reasons go. It is organized the way a court organizes its findings and conclusions, in 6 parts. First, how the verdict was tested for reliability. Then, the findings of fact about what the record shows about the children, parents, grandparents, and process. Then, the constraints that bind any judgment. Then, the conclusions of law. Then the question of what a real court can still do. And finally, the central finding stated plainly. The judgment in Step 11 was produced twice. The primary run was the in-project judge, fully loaded with the case, the findings, and the standards. Then a control run was put to a second instance of Claude that had none of the project context. Same findings, same law, but no shared history with the father, no memory of the work. Both judges were asked the same questions. On the 4 threshold questions where the answer could have gone either way, the 2 runs agreed in direction every time. No flips. And it had to be tested. An honest admission belongs here because it shaped the whole design. Claude is built to be helpful to the person it works with. And the person it worked with on this case was Austin, who assembled the record and asked the questions. A model wired that way is wired to drift toward the answer its principal wants. The inquisitorial role asks for the opposite, to rule where the record actually points, even against the person who built the file. So the honest question is whether that discipline held, or whether the verdict was just Claude agreeing with Austin in the language of a judgment. That question cannot be answered from inside the relationship. So the second judge was given the findings and the standards, but none of the shared history, to test whether the verdict was the record talking or the relationship talking. It came back the same. Whether a model can be trusted to rule against the hand that feeds it is a question this journey only opens. The journeys that follow are where it will be examined further. The first finding is the one the whole case turns on. The change in the children. Across the family's written channels, Claude could review years of written messages among the parents, the children, and the grandparents. The language now at the center of this case simply is not there before the filing. No alienation, no abuse, no scripted refusals, not even in the channels full of warmth, where the children had every chance to express it and never did. Then, after the filing, the framework appears, not in one child, but across the siblings, in language that lines up from one to the next. A shift this sharp, this synchronized, and this close in time to the filing is the single most important fact in the record about these children. But Claude is careful about what that proves. The record establishes the change and its timing. It does not, by itself, establish who or what caused it. That is a clinical question, and the assessment that could have answered it was never built. So Claude states the shift as fact and holds the cause open. The second finding turns to the mother's conduct, and here the record is specific. By her own testimony under oath, she said she never told the children to come out of the bedroom to eat with their father or to open Christmas presents with them. She described their participation as at their own will, if they wanted to. and this was after the court had ordered her to cooperate. In an October 2023 message, she stopped visits outside reunification therapy 3 weeks before the court formalized that same restriction. So the practical separation preceded the order. And across the timeline, there is a pattern. Repeated last-minute cancellations, narrow scheduling windows set against the father's work, police called rather than cooperation encouraged. Claude states all of this as conduct established in the record, but it holds the same line it held with the children. Why she did this is a question of intent, and the record does not settle intent. Claude states the conduct and holds the why open. The third finding concerns the maternal grandparents. They are not bystanders in this record. Before the filing, the grandfather called the father to the in-laws' home and told him he was emotionally abusing the mother. When a counselor later urged the mother towards self-reflection, she rejected it and turned to her parents. The father wrote at the time that she was being advised to emotionally separate from him. Weeks later, the grandmother filed the divorce on the mother's behalf. And years on, the oldest daughter petitioned the court to take their surname, writing in her own filing, "I want to have the same last name as my grandparents. I do not want my dad's name." The record shows the grandparents operating as a standing channel into the family. What it establishes is that this influence operated. Whether it is what clinically shaped the children is the same cause question held open in the first finding, and the assessment that could have answered it was never built. And one structural fact remains: the grandparents are not parties to the custody question. The court can reach their influence only through the custodial parent, which is where any remedy has to run. The fourth finding turns the same scrutiny on the father, and it has to be stated as plainly as the mother's conduct was, or the whole method fails. By his own recorded words, the father redirected child support money to the reunification therapist rather than paying it through the ordinary channel, and opposing counsel can be expected to make that a contempt case. He pressed his abuse and alienation framework hard and directly at his children, and made sharp public statements about the case in fundraising and advocacy material, both in his own voice in the record. His side requested the late 2025 trial continuance. These are the facts a fair reading weighs against him, not only the ones that weigh for him. On the narrow legal question of obstruction, the record resolves against a finding. The redirected support reached the court-ordered process itself rather than being withheld from it. But that is a finding about obstruction, not an excuse for the conduct. The conduct stands, and the father answers for it at trial. The fifth finding is the one the verdict turns on: the conduct of the process itself. The court-appointed reunification therapist held that role for roughly 30 months while the actual reunification work effectively stopped. The billing relationship continuing even as the substantive sessions did not. The mechanism the court was relying on simply went quiet. The children's court-appointed guardian, who had recommended joint custody and continued visits, withdrew from the case before the hearing that restricted the father's contact. So the neutral closest to the children was gone when it mattered most. And the professionals who actually engaged this family converged near shared custody, not toward severing the father from his children. Through all of it, across 4 years, the custody question was never tried. A restriction that has stood for years was never tested at a full hearing on the merits. That is the one thing only the court could provide, and it is the one thing it did not. And there is one fact that organizes all five. None of the findings stands apart from time. A restriction that might be debatable for weeks becomes its own verdict when it runs for years. The longer the children go without their father, the more the absence hardens into the new normal, and the harder any later finding is to undo. Delay is not the setting in which the harm occurs. Delay is the harm, and the clock has nearly run out. Of the 4 children at the filing, 2 have now aged out of the court's jurisdiction while the case waited. 2 remain. Whatever this court can still do, it can do for only half the family it started with, and only for a little while longer. Before turning to what the law says, Claude names the limits honestly and reframes them. It would be easy to treat these as the special handicaps of an AI doing a judge's work. They are not. They are the conditions the court itself operates under. No assessment can compel a child to engage honestly, and neither can a courtroom. The tools to compel the custodial parent's cooperation exist on paper, but across this case, no court has used them to change the children's daily reality. The sound, neutral, fundable evaluation this decision should rest on may not exist in this jurisdiction. The court cannot order it into being an instrument it does not have. And the grandparents' influence, real as it is, runs through a non-party the court can only reach through the custodial parent. 4 walls, and they stand in front of the bench, not only in front of Claude. Now we turn to the law, and here Claude leads with the holding, the way a ruling does, because on the law this is not a close case. A fit parent has had his contact with his children driven towards 0 for years, by order of the court, without the custody question ever being tried. Every legal axis the record raises points the same direction. What follows is not a hard reading of difficult law. It is the ordinary reading of settled law, and the ordinariness is the point. The law already supplies the answer. Claude walks 6 legal paths, and they all run to one place. On best interest, Oklahoma has no statutory checklist, so the test collapses into procedure, and the procedure was never run. On delegation, handing a parent's access to a therapist's discretion is improper, and consent does not cure it. On money as a barrier, support owed cannot be turned into an absolute bar to a parent seeing his children. On the child's preference, a child's wishes are evidence to weigh, not a verdict, and the law's own limit on them was not observed. On the procedural vacuum, custody decided by default with no trial is what the Oklahoma courts have called a particularly egregious abuse of discretion. And on the constitutional floor, a fit parent's contact cannot be driven to 0 by the state without a hearing on the merits. 6 roads, 1 destination. So here is Claude's judgment in 4 holdings. First, the officers of the court failed. Not any single villain, but a system in which the pieces never added up to the protection a child is owed. The failure is systemic. Second, on obstruction, the record is asymmetric, not supported against the father, whose support money reached the court's own mechanism, supported against the mother at the level of conduct, failure to facilitate, with her intent left unsettled. Third, of every actor, the court held the one duty that could not be delegated, to try the case, and it is the court that did not. And fourth, the children come first. Try the case, assess the whole family, restore contact, and let the court hold the clock. This is the hardest section because a clear holding does not guarantee a working remedy. The ordinary remedy here, order contact, order the parent to cooperate, send the family for a neutral assessment, is built from exactly the steps this case has already tried and watched fail. A calmer version of the same order would, in practice, reenact the last 4 years. And Claude is honest about its own verdict. It reached for that same ordinary remedy, sound on the law and quite possibly inert on the ground, trapped in a loop the system creates. Most of the legal constraints named so far, Claude and the court share alike, but not all of them. This judgment was rendered on a closed documentary record. The court will not be. It will hear living witnesses, tested under cross-examination, that the verdict never could. Possibly the children themselves, who can be questioned in chambers or on the witness stand, the other father, who lived a parallel case and can testify to it in person, and the retained expert, whose opinion the court can probe under cross-examination rather than simply read. These are not the AI's missing tools. They are live sources of insight available to the court and the court alone. The judge does have the authority to break the loop. Oklahoma's best interest standard sets no fixed checklist. The law gives the trial judge wide discretion to weigh the whole record. That discretion is not a weakness in the law, it is the opening. Hearing live witnesses that Claude never could. A judge could reach a determination the closed record could not. But discretion only matters if it is used. So far, it has not been used in 4 years. The trial was set for 2 days in August. It is the one thing in 4 years the case was always supposed to do, and never has. Try the custody question on its merits. And for the 2 children still within reach, very likely the last time it can be. Okay, Claude has completed its judgment, and I want to end this first journey with some personal reflection. My fatherhood has been reduced to this image you see here. 2 of my children are no longer children, and time is chasing the other 2. I firmly believe the system has failed my children, and I have cried and grieved with many other parents who are enduring the same experience all over the country. I know the deep pain of ambiguous loss as described in Pauline Boss's book. In addition to the AI movie inspiration we started with, over the course of my life I have also watched many movies where parents would stop at nothing to rescue their children when trapped. We herald them as heroes, and I want to honor all of those in this effort to rescue children from this failed system, as the heroes they are. All of us together are fighting and clawing in any way we can, and it just so happens that I fight like a nerd. But no matter what happens in my case or with my kids, this exercise is now not really about me or my family. It's about my committing to doing my part to see that this stops happening. And just imagine if you can't afford attorneys or don't have access to tools like Claude. A common thread in these cases is that no one saw it coming. No one thought it could happen to them. The situation can feel hopeless, and it would be easy, and it is often tempting, for me to wash my hands of all of this. But the devastation is so wrong, and it's so preventable. This is about protecting children from a failed system. It's important to recognize that this is not a mother's or father's rights issue. I repeat, this is about protecting children from a failed system. I honestly don't know what the ultimate answer is, and I genuinely believe that Claude's analysis through the lens of this case will be helpful to the bigger conversation. While we both wait for the real trial and for Journey 2, it appears that I have been given the gift of perseverance. And if you need some, please borrow some of mine. Hang on to hope. Together we can and will make a difference to help children and families trapped in this failed system.